Good morning, friends. I have got lot of requests from the various students regarding the difficulty they are facing into the IBC questions, especially the practical questions asked by the institute from the Insolvency and Bankruptcy Code 2016. And therefore, I have decided to release the small clip or a video for the benefit of students. This video will be useful for a CA final new course, corporate and economic laws, CA final old syllables, corporate and allied laws. It is also useful for a CS professional student for a subject corporate restructuring, insolvency, and it is equally applicable and useful for a CWA final corporate law and the compliances, right? So we are starting the question number 1. All the question I have designed is based upon the judgment delivered by the NCLT, NCLAT, High Court or a Supreme Court with reference to the IBC. You will find the question on the screen, right? I am reading it for your convenience as well. The first question is based upon the judgment delivered by the NCLAT in the matter of Ranjeet Karnal versus Bell Finvest India Limited. Let us understand what was a fact of the case or a question here. The Bell Limited has granted a loan to the M Limited. Now remember, my dear friend, when you are reading the question which is of the practical point or practical question, you are required to be a very much digestive reader, and you are not required to read it a very fast or in a hasty manner. If you will do so, I mean a fast reading, you may omit some of the fact, and which could be the fatal or a dangerous in terms of losing the marks. So Bell Limited has granted the loan to the M Limited. The corporate debtor has paid the first 6 months installment as per the terms of a loan. Now many students will have a question, sir, what is a corporate debtor? Here, who is a corporate debtor? M Limited is a corporate debtor. The Bell Limited has granted the loan, so obviously the Bell Limited will be considered as a financial creditor, and the loan granted will be considered as a financial debt, right? On a 2nd November 2018, the M Limited by the registered letter informed the Bell Finance about its new address and request to communicate at this address only. And it is a very routine process in a corporate, the place change, and therefore the new address is communicated, and then the other person or a third party is required to communicate at the new address, especially when the formalities are over. On a failure, the Bell Limited has served the demand notice at the old address of M Limited, and on a failure on the part of M Limited, filed appeal to the NCLT to initiate CIRP, that is Corporate Insolvency Resolution Process, on a 5th of January 2019. The NCLT has initiated CIRP and appointed the IRP, that is an interim resolution professional. The NCLT has initiated the CIRP and appointed the IRP. Ranjeet, on behalf of the company, that means M Limited, right, appealed to the NCLAT, National Company Law Appellate Tribunal, that M Limited has never received the notice served by the Bell Limited, a demand notice. At the same time, the copy of a notice served by the adjudicating authority for a hearing is also not received by the company. Advice. Now, here the question is that who is right, and whether the order of initiating the CIRP by the NCLT is appropriate or not. Now that fact we will have to decide. Let us understand what is the requirement of a IBC in this regard. The financial creditor on a default on the part of a corporate debtor can initiate the CIRP, but as per the rule number 4, the demand notice is to be given. Certain forms like the application is made in a form number 1. Application should be a complete. The name of an interim resolution professional should be suggested or should be included, right? And the demand notice should be served to the registered office of the corporate debtor. It has to be served by the particular method. Here we are not concerned with the method because the point is not with the method, but the point is address. It should have been addressed at the new address, but instead of that, the company had served it at the old address, right? So now the first point is that whether the communication of a notice has been made by the financial creditor to the corporate debtor in a good manner or as per the provision of the code. You can understand from the fact that it has been communicated, a change is communicated on a 2nd November, while the notice, demand notice, has been given on a 5th of January. So the financial creditor was aware about the change in address, and therefore they should have served the notice to the financial creditor at the new address. But in spite of having the knowledge of the fact about the change in address, they served it at the old address, and therefore it cannot be said that the proper notice was served by the financial creditor. Point number 2, once a notice has been given, an appeal is filed with the NCLT. The copy of the notice with the date of a hearing is served by the NCLT to the other party, that means a corporate debtor, which is also missing here. And therefore, if we combine the two facts, notice not issued by the financial creditor, at the same time the notice has also not been given to the NCLT with regard to the hearing, it has deprived the right of a natural justice from the corporate debtor. And in the absence of the opportunity of being given, you cannot initiate the CIRP. And therefore, the NCLT in this case held that the notice has not been served, and therefore the CIRP cannot be initiated, right? The order of the NCLT was set aside. Now here, if you refer the last line again, that it suggests that at the same time the copy of the notice served by the adjudicating for a hearing is not received. I have taken the little deviation from the case, right? If the notice has not been received, if it has been properly served, right, then the adjudicating of authority has done what they should have done as per the provision of the act, and they are not at the fault, right? But we cannot miss the point that the financial creditor has not given the demand notice, has not served the notice at the address which is known to them. Instead of that, they served the notice at the old address. And therefore, again, the rule of a natural justice has not been fulfilled. And therefore, the judgment of a or an order of a NCLT to initiate the CIRP without the rule of a natural justice is not a proper.